Hi, this is Professor William Wagner, and we're at the U.S. Supreme Court today in the case of 301 Creative. It is a case that involves a Christian web designer who is being compelled by state authorities in the state of Colorado to engage in speech on her websites that she designs, being compelled by the Colorado government to engage in speech inconsistent with her sincerely held religious beliefs, and at the same time being censored by the Colorado government and their Civil Rights Commission from being able to, again, act in accordance with their sincerely held religious beliefs. In this case, I represented the legislators in the state of Colorado who, for the most part, were people of faith, but were strong proponents of freedom of speech and following the law, sworn to uphold the Constitution. These legislatures hold a special commitment to constitutional governance under the rule of law. This understanding includes a deep respect for the constitutional limits on the exercise of government power, including, and especially in this case, the Amendment, freedom of speech, and the free speech clause of the First Amendment, rather. These legislators are profoundly concerned by the willingness of state authorities who, by force of law and punishment, are censoring this Christian person named Lori, censoring her viewpoints and ideas, just because they are inconsistent with preferred political preferences of the state, and also at the same time compelling viewpoints and ideas that are consistent with their political preferences. Now, to be sure, the other side during oral arguments today, didn't frame the issue this way, and in spite of stipulated facts to the contrary, tried to make this all about not that Lori is acting in the with regard to her sincerely held religious conscience, but they claim that she's invidiously discriminating. They've got bad, corrupt motives for discriminating against the person based on their status. Nothing in the facts seem to support that distinction, though, and that's why this case is so important. Because the First Amendment to the Constitution serves as a limitation on the exercise of government power. Ratified in 1791, the First Amendment to the United States Constitution provides that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. This language includes no exemption for laws that compel or censor a person's speech because the government disagrees with the idea or the viewpoint expressed. And that's exactly what is happening here. The state of Colorado disagrees with the idea or viewpoint being expressed by this Christian person. Bearing witness to the intolerant laws of the 17th century England, that persecuted individuals because of their religious views, the First Amendment balances the need for freedom of speech and religion with the need for a well-ordered, centralized government. Now, the First Amendment speech clause embodies an idea that is very uniquely American. That is that liberty exists only where people are free to hold and express conflicting political and religious viewpoints. Under this idea, the government must not interfere with the citizens and the way they live out or express their freedoms, but must embrace rather the security and liberty that only a pluralistic society affords. Now, the free speech clause protects expression of a religious person's artistic viewpoint and ideas, and that limitation subjects a state and the exercise of state power to the strictest scrutiny if the government, like they did here, interferes. And there are a lot of Supreme Court cases that make this very clear. In In one case, for example, the court unanimously reaffirmed that government may not exclude speech based on religious viewpoint. Doing so constitutes impermissible viewpoint discrimination. Now, when we go into Colorado, we look what actually is happening here. The Civil Rights Division of the Colorado Civil Rights Commission enforces the Colorado Anti-Discrimination Act. Now, while the division investigates, the commission adjudicates. And so you've got these unelected bureaucrats that are investigating and adjudicating a person's fate here. And that's why many of these legislators that we're representing in this case, are not happy. They are seeing exercises of government power that's not politically accountable to anybody, because these bureaucrats don't have to run for an election. And at the same time, they seem to be just ignoring the limits on the exercise of their power that are specifically in the U.S. Constitution and specifically in the First Amendment. So in its most recent endeavor to force acceptance of these political policy preferences, this Colorado regime is using a public accommodation law to censor the petitioner here, Lori's viewpoint, a religious viewpoint that is absolutely consistent with her conscience and inherent in her personal religious identity, and has nothing to do with the status of the person that is seeking the services. Has nothing to do with whether or not a person expresses some kind of sexual identity or not. Moreover, Colorado here, the regime in Colorado compelled her to engage in expression that conflicts with that sincerely held religious conscience. Now, here's what's remarkable. A panel of the 10th Circuit United States Court of Appeals found that Colorado did substantially interfere with Lori's First Amendment liberty. Now, the problem is they said, but we're going to say that interference was justified. And so unless the Supreme Court affirmatively acts to correct this U.S. Court of Appeals decision, and what the Court of Appeals did here, make sure you understand this, it was a disturbing diminishment of the free speech clause, and unless the Supreme Court addresses the systemic misapplication by the Colorado regime here, Colorado's action as a practical matter denudes any meaningful constitutional protection for liberty as a limit on the exercise of state power. So when the government policy preferences unfairly interfere with fundamental First Amendment liberty, bad things happen, folks. Ubiquitous special preferences for sexual orientation and gender identity, and I'm just going to say SOGI from now on, imposed by the states, supposedly in the name of protecting freedom, too often threaten fundamental, unalienable First Amendment liberties. These government actions necessarily require religious people, here a Christian artist, to relinquish their right to artistic expression inhering in their personal religious identity. Through the faith perspective of her Christian identity, here, Lori, the web designer and the artist, Lori, creates an original content for websites. She desires to bring glory to God, and does so by way of creating unique expressions that impart her thoughts, her views, her conscience, including her understanding of God's design for marriage as the union of one man and one woman. Here, Lori hoped to expand her business to include wedding websites, promoting her understanding of God's design for marriage, encouraging commitments to lifelong unity and devotion. And you can go to the record and see where her lawyers have made those arguments and where the facts of the case have been stipulated, so that there really isn't a disagreement on what the facts are here. It's just whether or not the government should be able to be justified in interfering with Lori's First Amendment freedom of speech rights. The state said, we can do it. We can mess with your rights, even though it concedes that Lori was, and this is a quote, willing to work with all people regardless of race, creed, sexual orientation, and gender, end quote. Why? Because Lori, as a matter of who she is unable to engage in artistic expression promoting a message that conflicts with her sincerely held religious conscience and identity. Now, Lori hoped to express an online message explaining why, as a Christian person and artist, she could only engage in speech that was consistent with her religious identity, or in here, her Christian faith. Here again, the state said no, relying on their anti-discrimination law to restrict Lori from engaging in expression consistent with her conscience and inherent in her personal religious identity, all the while compelling her to engage in expression that conflicts with that sincerely held religious conscience. This is an important case before the court right now, folks. And it doesn't just impact religious people, it impacts all people. Can the government compel speech? Can the government censor your sincerely held conscience? The government imposed speech conditions in this case substantially interfered with Lori's freedom of speech. Because Colorado's law restricts and compels expression based on content, the lower court got one thing right. They correctly held that the government had to satisfy this very high level of scrutiny. In the law, we call it strict scrutiny. Anytime a law is substantially interfering with one of our fundamental inalienable rights. The lower appellate court's opinion grievously erred, though, when it held that anti-discrimination statute should survive this strict scrutiny. They recognized that it was interfering with inalienable fundamental rights, substantially so, and then said, we're going to justify it anyways. Because the court below found that the Colorado regime had a compelling interest in safeguarding the access to Lori's so-called unique services, notwithstanding that these customers in the LGBTQ community could obtain wedding website design services from many other businesses. Here's the other thing that is really important to understand, that the lower court's opinion absolutely conflicts with the U.S. Supreme Court's prior Supreme Court precedents protecting expression. Application of a public accommodation law can unconstitutionally burden protected speech if the law targets speech, or rather when, I suppose, the law targets speech, when it alters the expressive content of the message, or when it interferes with an individual's choice not to, propound or carry out a viewpoint conflicting with their beliefs. If a public accommodation law has the effect of declaring speech itself to be the public accommodation, this is protected speech, and there's Supreme Court cases, many of them that say this. And the lawyers on behalf of Lori today did a very good job of articulating those precedents and the sound legal reasoning, underlying the current constitutional rule of law. And the other thing that I think was very clear from the court's arguments today on behalf of Lori, that the lower appellate court's ruling, it just can't be reconciled with one holding in particularly. It was called the Hurley case. In Hurley, the Supreme Court held that the First Amendment gave organizers of a private St. Patrick's Day parade the right to not communicate a message about homosexual conduct to which they objected. Now, again, the parade was considered a public accommodation, just like this business of making websites is considered a public accommodation. So in many ways, they're very parallel cases. The First Amendment protected the parade organizers' right to not propound a particular point of view. I'm quoting from the court decision there. And this court protected the principle of a speaker's autonomy. In doing so, the Supreme Court unanimously ruled that a state's public accommodation law, like the law in this case, must not be applied to compel a speaker to communicate an unwanted message or express a contrary viewpoint. The Supreme Court condemned the notion that public accommodation laws, again, like the one in this case, should force free individuals to express and convey messages to which they disagree, because the use of the state's power, and I'm going to quote here again, the use of the state's power violates the fundamental rule of protection under the First Amendment that a speaker has the autonomy to choose the content of his own message, end quote. The court in that Hurley case noted that this general rule that the speaker has the right to tailor the speech applies not only to expression of value or endorsement, but equally, folks, to statements of fact that the speaker would rather avoid. That's why we need free speech, people. Not because we need something to protect us against speech that everybody agrees with, but to protect us against speech that the government doesn't like. And the benefit of the rule, the court said in the Hurley case, is not limited to the press or to just some people, but it's enjoyed by business corporations generally. And that's what Lori has here, is a corporation. This court that we are in front of today, in later applying that Hurley case, they noted that the parade organizers did not wish to exclude the LGBTQ community because of their sexual orientations, but because they wanted to march behind a banner that had a message that the organizers disagreed with. And in Hurley, the parade organizers did not seek to discriminate against anybody based on who they were, but they did wish to communicate their St. Patrick's Day message as they saw fit without being compelled by the government to adopt or promote other messages in the parade. And like the parade organizers whose First Amendment rights the Supreme Court protected in the Hurley case, Lori does not and has never wished to discriminate against anyone based on their sexual orientation or who they are. Given that Lori willingly serves anyone without regard to their sexual orientation, lifestyle, it's not her customer's sexual orientation that creates the problems in this case, folks. Rather, it's solely the government's action compelling and censoring Lori's expression. Lori, the web designer here, believes that all people are created equal, but she reserved the liberty to abstain from affirming that all conduct is the same, especially when such a message violates the Christian faith central to her identity. The First and 14th Amendments afford the liberty to not be forced or compelled by the state, and here Colorado, to do this kind of thing, to engage in speech you disagree with. And as the Supreme Court has previously declared again, once again, these precedents are there. They've never been overruled, and they're soundly and rationally and reasonably decided, and there's no reason to overturn these precedents. The court previously declared, while the law is free to promote all sorts of conduct in place of harmful behavior, it's not free to interfere with speech for no better reason than promoting an approved message or discouraging a disfavored one, however enlightened either purpose may strike the government, end quote. Again, that's exactly what the regime in Colorado is doing against Lori in this particular case. A government interpretation that punishes a dissenting opinion by promoting another is never been considered constitutional. Tolerance, folks, has to be a two-way street. Otherwise, the rule, as the Supreme Court has stated in another case, otherwise the rule mandates orthodoxy and not anti-discrimination. Again, that's what the Colorado regime is doing. It's mandating orthodoxy. It's not doing anything to stop discrimination. Government SOGI preferences enforced by way of censored and compelled speech regulation too often unconstitutionally collide with the expression protected by the First Amendment. When you've got state regimes enforcing speech codes, state enforcement of speech directives, advancing, preferences of those bureaucrats that are bringing these charges. Too often we see state enforcement of these speech directives advancing these preferences in ways that weaponize state action to eliminate the free speech clause as an important constitutional constraint on the exercise of a state's authority. Indeed, folks. religious people in our nation face a far more onerous predicament than the drafters and ratifiers of the Constitution and Bill of Rights could have ever even imagined. The beacon of liberty fails to shine when freedom dies on the pulpit of the civil authorities' demands to supplant its will and opinion of morality for that of its citizens. The promise of liberty amounts to nothing more than empty subterfuge when state regimes like Colorado punish its citizens for expressing their thoughts and views, inhering in their personal identity, especially their personal religious identity. Persecution of religious identity by way of censorship and compelled speech imposed by the state upon Lori and other people like her must not stand in this country. This is the United States of America still. The First Amendment passed and promulgated to protect free expression and religious tolerance requires reversal of the lower appellate court's oppressive and overreaching judgment. That lower court agreed that the government here, through the power of the state, can both censure and compel a devout Christian artist's expression of her artistic message to comport with the government's political policy preferences. If this holding is correct, the American experiment, folks, is over. For devout citizens, this kind of rule fatally erodes freedom of speech, thought, and conscience inherent to one's dignity, autonomy, and identity. If government can compel you as a citizen in your speech to dishonor God or else lose your livelihood, we're far down the road to tyranny, and a tyranny not so dissimilar from that which caused many to flee so far to our shores all those many years ago. People, leaders, giants on whose shoulders we stand here today, arguing that we have to stand for truth. We have to stand for the free exercise of religious conscience, or our nation faces some very, very, very dark times, very, very dark times ahead. And so those were some of the reasons we argued in our brief that was before the court today, and the arguments were made today. I hope it helps you understand what's happening in front of the court with regard to this important case on the free exercise of, the free expression of thought, conscience, and religion. It matters that we understand what's happening, because if we don't, then all you're going to read in the press tomorrow is that Lori had some kind of bad intentions and was intentionally discriminating against somebody based on their status of who they are, as opposed to the truth of what is really going on here is that the government of Colorado is intentionally and substantially interfering with the free expression of a Christian person's views simply because they disagree with those views. So until next time, this is Professor William Wagner, and for the Faith and Freedom Center and the Great Lakes Justice Center. God bless you, and stay strong. Be fiercely unafraid to speak the truth, but always do it with compassion and respect.